Good afternoon. As you know, my name is Judith Sandel. I'm the director of the Children's Law Center. I'm also a resident of the district, a proud resident of Ward 1, and was an extremely close friend of one of the murder victims who Mr. Graham spoke about. And I tell you that, I'm testifying today on behalf of the Children's Law Center, but I tell you that because I want to make as strong a point as I can, is that I believe I am testifying in support of all of these kids, both on all sides. As you know, the Children's Law Center is the largest nonprofit legal services organization in the district. We're the only organization that devoted to a full spectrum of children's services. We represent 1,200 children every year, and obviously through this work, we are extremely familiar with the laws regarding confidentiality of children's court records, other documents, and the effect it has on kids. I couldn't speak more eloquently than the previous witnesses, so I'm not going to try and repeat their testimony. I endorse everything they have said. I want to make clear we support what I believe to be the broad goal of the bill, which is to ensure that persons who are providing services to children have access to the information they need to provide it properly. And at the same time, I think the bill's too sweeping in its language. It will cause more harm than good for all the reasons that have already been said. And that information is currently allowed to be shared. The right information can now actually already be shared in order to let children get the proper services they need. Fundamentally, Children's Law Center believes that highly sensitive and personal information about a child and a family ought to remain confidential in most circumstances for all the therapeutic reasons that were mentioned before, both for the inaccuracy potential, for the closing down of families. As you probably know, juvenile social records include an unbelievably detailed and personal amount of information. And those social records belong to the child, not the court case. So a kid in a delinquency proceeding, for example, who also is a subject of a neglect proceeding, that all the information from the neglect proceeding would be information provided to the public through this bill. That information includes detailed allegations of physical and sexual abuse. It involves the child's home address. If the child's in foster care, it may include the address of a foster or adoptive parent who does not want the child's whereabouts to be disclosed. It includes mental and physical health evaluations and just a ream of other personal and sensitive information. And has already been testified to, the bill as written allows that information to be divulged to an extraordinarily wide range of people. The number of folks who contract with the District of Columbia doesn't have to be to provide services to kids, is extremely wide. And I want to say that the bill encompasses everyone from clergy to public housing managers who are mandatory reporters. So all of those folks would have access. In some situations, such as those involving domestic violence, it's critical to a family's safety that the personal information remain confidential. And this bill would open the records to folks who are serving batterers to get access to that information so that the disclosure is extremely broad. There are also some very practical problems with the bill. Most importantly is who decides. Would members of the clergy, any mandatory reporter, simply show up in the clerk's office and ask for records? Who gets to decide who has a legitimate professional interest in the child, and how would this be documented? Sort of, what's the mechanism? The bill doesn't spell any of that out. In addition to being harmful for all the reasons in my written testimony and what I've said today, it's really not clear how the bill is going to help children and families. As others they testified earlier, it's just not necessary for government agencies working together to have access to these particular records. As most of our clients are involved in the child welfare system with CFSA, I can assure you that this bill is not necessary for the children in CFSA custody to receive services or treatment. CFSA's own policies provide that in general information in the possession of CFSA and in contracting agencies regarding clients is confidential. However, such information may be disclosed for a variety of reasons, including the identification of service needs or resources, and I turned the wrong page, so I'm going to read you the wrong information. And to secure or provide treatment or direct services to the child or other identified individuals. And I have the site in my testimony. CFSA already has the needed latitude to talk about otherwise confidential information when it's necessary and appropriate. And we believe rather than giving thousands of people open access to records, it is much more appropriate to allow CFSA caseworkers to reveal such information when, in their professional opinion, it's warranted. In conclusion, this bill opens access to confidential information far too broadly, and the needed addresses is unclear. We therefore urge you not to move it out of committee. Thank you.
Thank you.